Good afternoon and welcome to today's installment of the AIAC's Diversity in Arbitration Week 2021, organized in collaboration with the Chartered Institute of Arbitrators Malaysia. My name is Sharifah Shazuwin and I am a case counsel here at the AIAC. Today, I, alongside my co-interviewer, have the privilege of interviewing Captain Milind Karkhanis on his interview as an arbitrator in the maritime industry. He holds 43, going on 44 years of experience, not only as a commercial shipping man, but also involvement on board the ship itself, including training of seafarers. Stay tuned to listen to the exciting stories the man has to offer. On that note, I would like to introduce my co-interviewer, Mr. Choon Hon Leng, the chairperson of the Chartered Institute of Arbitrators Malaysia and a partner at Darryl Loh. His experience in construction law includes construction adjudication under the Construction Industry Payment and Adjudication Act 2012 and as lead counsel in several construction arbitrations, including arbitral proceedings conducted wholly in Mandarin under the China International Economic and Trade Arbitration Commission arbitration rules. Without further ado, let's begin the interview session. I invite my co-interviewer, Mr. Choon, to ask the first question.
Hi, Captain. With the extensive background in the maritime industry that you have, what inspired you to pursue a career in arbitration, and how would you describe your journey to date?
Hello, Choon Hon and Sharifah. On your first question, probably why I pursued my career in arbitration stems from my passion for law and probably also my heritage. My dad was a senior advocate and a public prosecutor in the Mumbai High Court. And my dad's cousin was India's Minister of Law for Social Security in the year 1965-66. So there has been a kind of a heritage related to law. And I always enjoyed resolving disputes, as a passion. So it's basically the passion for the arbitration.
Moving on to the second question. Captain, tell us, what does your typical day look like? And how is your involvement in arbitration, especially as an arbitrator, has changed that?
I've been in the marine industry, as you mentioned at the beginning, 43 years. And I've been at sea, I've been as a master mariner and also ship management experience. So I do consultancy. I represent a few companies, including one of them being KVH, which is VSAT, which is into VSAT communications business. It's besides arbitration, I do this consultancy. So when I'm not doing arbitration, I look after the interest of the companies, maritime companies I represent. When I'm doing arbitration, as you know, is very involving, needs a lot of research. Every case has a lot of research. But otherwise, I'm involved in consultancy over an array of companies with my background in maritime for over 43 years.
Thank you, Captain. What would you consider to be the key highlight of your career as an arbitrator?
The key highlight would be, I would say every case is different. And that's the variety of arbitration. And it is very interesting that, every case has a different slant. But as regards to highlight, I would say in terms of the amount of claim and counterclaim, I have been appointed on a very interesting case where the claim is $3.8 million and out of which the counterclaim is 900,000. So 2.9 million claim and 0.9 million counterclaim, which is 3.8 million in total US dollars. And it's a very interesting case, very involving case. Basically, I was appointed by a city law firm. I cannot go into the details of the case. The case is going on, and arbitration is a very confidential procedures are very confidential. So I won't go into much details, but I can say it is a very interesting case where the vessel loaded the cargo of grain in USA, and it was raining heavily while they were loading. That they completed the loading, and when the different certificates were provided, the master realized that the moisture content was too high, and he could see the water below the, he could realize that there was water in the cargo hold, which had seeped through, and therefore he could not start the passage. And the vessel had to, he took a decision not to sail out, but to get the cargo discharged. And discharging a cargo in the port where you've loaded, where there are no means of standard means of discharging, you have to have a special barge and do it with a small grab. It takes time. So a very complicated case. But yeah, it's interesting as well, because the claim is now, total claim and counterclaim is 3.8 million US dollars. So it's a very interesting case, which I'm into. So yeah, I would consider that as my a key highlight in my arbitration career so far.
I see. Wow. Thank you so much for sharing with us. We always say that the first step is the toughest. How did you go about securing your first appointment as an arbitrator? Do you have an advice, any experience you want to share with us on what that needs to be done for up-and-coming arbitrators to be?
I did my Master Mariner qualification. Then I was as a master, as I mentioned. Then I came ashore. I was as a ship manager in Hong Kong with a ship manager. I was looking after the safety, quality, and operations. And I had an opportunity to enroll myself. And because of my passion, I got enrolled into doing master's post-graduation in arbitration and dispute resolution from the City University of Hong Kong. That was a 2.5 years structured part-time course. So that gave me a good insight into arbitration. And later on, when I moved to London, I just kept knocking on the LMA door and attending annual seminars, annual lunches, annual dinners, and interacting, networking with arbitrators. And I was very fortunate that a few years ago, LMA said that, yes, okay, we'll start giving you cases, and I get most of my cases from the LMA. So yeah, I mean, I think it's just perseverance, patience, and passion, I would say, to any newcomer to keep knocking at the door, and so over a period of time, the cases will start coming in.
Well, thank you for the tips and guidance. So with that dichotomy of legal versus non-legal background arbitrator, what unique insights or perspectives do you believe those from the non-legal backgrounds can bring to an arbitration proceedings?
I think it is very important that and useful for a commercial person to be on the arbitration panel. It is very, very important that a commercial shipping man gives his insight of practical sailing on, having sailed on a ship practically. It is one thing reading a book about sailing and sailing actually, and physical experiencing what are the vagaries of sea, what are the challenges of sea, and how you encounter them. So that knowledge is very specific. However, the best way I would answer your question is to give you an example. I was on a tribunal where there was a case of, again, I can't go into details of the case, but briefly, there was a case of 4 stowaway who came on board, who were found on board after the vessel had sailed out of a European port. And the owners had to expense huge expense, to disembark them, because they could not disembark them in the next port. They were having, they did not have any travel documents. Then the vessel went to Canada. There also they could only send off 2 of them, disembark 2 of them. The 2 remained on board. The vessel went to Port of Spain in the Caribbean, and so it prolonged, and a lot of expenses were incurred. And that's the owner came and they took the matter to the arbitration. Now, the other arbitrator on the tribunal was a very, very experienced, highly experienced ex-partner, solicitor partner of a very reputed city law firm. And when we had all the documents, we discussed we said, let's discuss it on the phone and see what is our conclusion. So he said, the owners are responsible because the anything away from the gangway into the ship, the owners are responsible because they were detected after the vessel sailed off. I said, no, in my humble opinion, it is the charterers, because it is charterers owners to, he said, how do you do that? Then I said, it is the way the containers are loaded. So he says, well, let's meet physically, and rather than talk on the phone, and you explain me the details. So we met, and I explained how the containers are stacked in the yard, because when the stowaways were found, they were found coming out of a container, and the container which they pointed out after they had, they described to the master, their container was on too high. So, and the container had a small cut so that only a hand could slide out and open or close the lever from outside. So they were inside the container and they locked the container. The container was loaded on board and unlocked the container. This has happened when they were ashore. You cannot cut a container so easily on board. A container is a very strong steel door. So the sides are very strong. So I explained to him the details, and he says, well, great, you have managed to change my opinion 180 degrees completely. So now I understand it is the charterer's responsibility. So this is the insight. Because of my professional background, I could explain to him very easily. Also, there was another case, I can give another case where the claimant claimed with a shortfall of bunkers. There was a claim for bunker shortage, which the charterers refused to pay. And eventually the claimant owners, they submitted all the documents. One of the, in their statement of claim, they had adduced a few documents. The defendant also put their, respondents also put their statement of defense and the documents, and the claimant had included engine logbook. So because of my background as a master mariner, having said, I went through the minute details put in the engine logbook, and it was very clear that the vessel had in fact not loaded that amount. It was shortfall. There was a shortfall, and they had, in the engine logbook, the figures were correct in terms of shortfalls. So the claimant, although they had claimed, had lost the claim. And I could go into the nitty-gritty of the engine logbook because of my knowledge on shipboard operations. So these are the things, matters. And I think a tribunal where there is one commercial maritime person and the other one or two is a lawyer, ex-solicitor, ex-lawyer, that gives the best blend, I would say, where there's a law element which is taken care of, that is procedure, proof, evidence, and the commercial shipping man brings the practical element, what actually can happen on the ship, and how, to give a reality to the whole issue which has come up for arbitration. So yeah, I mean, I do believe that non-legal background helps.
The sneaky stowaways, but they wouldn't be stowaways if they're not sneaky. So these are views of those who are in the legal background, but no specific experience or knowledge in maritime. But as someone who came from a non-legal background, what are the specific challenges that you think that those who come from non-legal backgrounds need to overcome in order to succeed in international arbitration? And how did you overcome that?
There are a few very important challenges for a person from non-legal background. And one of them, as I mentioned, is to understanding the procedural matters. For example, when a party keeps applying for extension, where do you draw a line where there is delay and where the extension is justified? If a party applies for security of cost and keeps, and then there is security of cost from a London bank or a non-London bank or an insurance company, P&I company. So these are the, various factors which have to be taken into account. Also, writing award. The award has to be very cogent, very, very, convincing reasons. It has to be the facts, the arguments, the parties' arguments, the facts, the reasons have to be placed in a very orderly manner in the award. And a lot of common law system, lot of referencing is required. So you have to do a lot of case research. And all this needs a little bit of background. So my MA in arbitration did help, and it does help to bridge that bit of a gap. So there are challenges for arbitration from a non-legal background. So if we can, sort of get trained from a legal aspect, the Chartered Institute of Arbitrators in London, they have good courses. So there are few courses they can bridge that gap. Writing award is a skill which is very, very important. Doing a proper research on the case, how to proceed with the case. These are the important challenges where you need some training. And I think the Chartered Institute of Arbitrators does that training. There are a few others who do the training. So yeah, it helps if a person from non-legal background does these courses. It gives that kind of confidence, I'm sure. So these are the ways challenges can be overcome.
Thank you, Captain. So what does professional diversity in international arbitration mean to you? And in your opinion, as we speak now, has this been achieved?
Another good question. Professional diversity in my mind's eye would be, as I mentioned earlier, an arbitration tribunal having one commercial shipping man, and there was a case in 1987, Vincor Shipping versus Transatlantic Shipyard, where the judgment described what a commercial shipping man is, and it was defined as long as they were not practicing lawyers. So I think the best balance for a tribunal would be to have a commercial man having knowledge of shipping, which is so very unique. I think we are slowly getting to it, but there is a long way to see it as a norm. Still, the commercial shipping man as an arbitrator is not appointed on many arbitration cases. So I would like to see more appointments like this. And I'm sure, institutes like arbitrational institutes like LMA, SCMA, CIArb, such institutes could promote, like LMA is doing, promote appointing such commercial shipping man as an arbitrator. And I would say even organizations like BIMCO and ICS can have a clause. BIMCO can have a clause in their arbitration, in their charter party arbitration clause. ICS, the International Chamber of Shipping, can also push, because I believe it brings a great balance, and it is somewhat desirable, preferred way for a tribunal to have a commercial shipping man. So it is not yet, we are not there, but I think we are slowly moving to it, and I hope we move and make it a norm. We move faster and make it a norm.
Aside from appointments and pushing for other institutions to promote diversity, I like to think that AIAC took it up a notch. So with this AIAC's Diversity in Arbitration Week, what are your thoughts on our initiatives and in promoting professional diversity in international arbitration?
Absolutely. I mean, you have just continued in the right way. I'm very thankful to the Asian International Arbitration Center to promote diversity and put it as a week in 2021, diversity in arbitration, and giving it more credence, giving it more weightage, and I think, as I mentioned, your center's initiative is very laudable, and I'm delighted that you're doing it, and I'm delighted that you're asking me questions based on that, and it's a great thing. I hope the other associations, other institutions, institutional arbitration centers also come out with such promotional activity. So yeah, thank you for that. Much appreciate your efforts. Well done on that.
Thank you, Captain, for the very insightful sharing. In my mind, one of the most valuable feature and benefit of arbitration is that parties are given the power to choose their tribunal. So it is my belief that while legal aspects are always important, because ultimately arbitration is still a formal legal process and disputes have to be decided by principles of law, the role and advantage of having someone armed with the specific technical knowledge cannot be understated. This is particularly so when disputes are getting more and more complicated, and more significantly, with a heavier international flavor crisscrossing different jurisdiction, practice areas, legal systems, and culture. In order to ensure that arbitration continues to be preferred as an effective and fair dispute resolution process, and to retain the confidence and trust of the users have in arbitration, having that diversity or that variety is a major ingredient for us to achieve that. So thank you, AIAC, for taking this initiative, and I hope all of you had an enjoyable session. Last but not least, thank you to all of you for being with us for the session. Thank you.
Thank you. Thank you, Choon Hon. Thank you, Sharifah, for giving me the opportunity.
Thank you, everyone. And that concludes our interview for today.